Welcome to the latest Evershed Sutherland Legal Insights podcast.
Hello and welcome to Conversations in Credit, the podcast where we look at the latest developments and insights in the world of consumer credit. I'm your host, Alexandra Byard, a senior associate at Evershed Sutherland. Today has been a busy news day. Not only have we had the CCA reform phase 1 consultation released, which I have just finished a podcast on. This podcast will be running through our flash briefing, which we have also released, discussing HM Treasury's response to BNPL consultation and what it means for consumers and firms alike. So BNPL, which is buy now, pay later, refers to that type of interest-free instalment credit that allows borrowers to split the cost of purchases into regular repayments due within a 12-month period by 12 or fewer instalments. By structuring agreements in this way, firms have been able to rely on an exemption set out in Article 60F2 of the Financial Services and Markets Act 2000, Regulated Activities Order 2001, which is the RAO. So firms do not need to be authorised and regulated by the FCA, nor did they have to comply with the requirements of the Consumer Credit Act, so CCA. The government has, as we know, over recent years become increasingly concerned about the expansion of this type of unregulated credit product, having already consulted twice before on the regulation of these products. HMT has published its response to feedback received as part of its previous consultation and has set out the framework for its regulation of BNPL, together with the Financial Services and Markets Act Regulated Activities Amendment Order of 2025. So a few key points from our flash briefing. The retention of the distinction between the treatment of merchant-offered BNPL versus third-party lenders. So BNPL lenders will be subject to the new regulatory regime, whereas merchants who provide credit direct to their customers will remain exempt. There's limited information requirements, so HMT have confirmed that applying the CCA's information requirements to BNPL products would be disproportionate and would not align with its goal of maximising consumer understanding of these products. Following information will not be required for BNPL products, but will be replaced with the new FCA rules yet to be drafted. So these include pre-contractual information, so that's the adequate explanations and the PCCI, the current form and content of agreements, any ongoing information requirements, information on variation of agreements, early repayment information, and information on arrears, defaults, and termination. HMT reiterates that it is working at pace to reform the CCA, and as part of this has issued proposals to repeal the CCA's information disclosure requirements and recase them into FCA rules. These same proposals would mean that all consumer credit products could therefore soon benefit from the FCA's modern outcomes-based regulatory framework, including BNPL. Time orders will remain available for BNPL agreements with an acknowledgement that the FCA will develop rules tailored specifically to BNPL products. Section 86 of the CCA, which requires a lender to apply for a court order if it wishes to take certain enforcement action following the death of the debtor, will apply to BNPL agreements. CCA sanctions will not apply to BNPL, with consumers being protected instead through compliance with Consumer Duty and the FCA's oversight of BNPL firms. The proposal to disapply the DMRs, so that's the distant marketing regulations for unauthorised brokers where information is disclosed by authorised lenders, but there will be consideration of this as part of phase 2 of the CCA reform work. In terms of credit broking, merchants offering BNPL products will will be from the requirements to obtain credit broking permission. Credit broking for other regulated credit products will be reviewed in any case as part of the CCA reform. Financial promotions, BNPL firms in the temporary permissions regime will not be able to approve financial promotions created by unauthorised merchants. However, firms in the temporary permissions regime will be able to approve their own financial promotions for onward communications by unauthorised merchant partners. The temporary permissions regime will enable BNPL firms that are not yet authorised to carry on consumer credit lending or credit broking activities to continue their BNPL activities while their application for full authorisation is being reviewed. The FCA will draft and consult on its rules for that in due course. In terms of wider feedback, reporting to the credit reference agencies. So HMT will maintain ongoing engagement with credit reference agencies to closely monitor the reporting of data related to BNPL agreements. The senior managers and certification regime. Firms in the temporary permissions regime will be exempt from the SMCR, which is your senior managers and certification regime, include both the senior managers and the certification parts of the regime. Scottish registered social landlords. So HMT intends to proceed with plans to grant a regulatory exemption to registered social landlords who offer BNPL agreements to their tenants. The drafting has been updated to include provisions also for shared ownership arrangements in Scotland. Finally, interaction with the Payment Services Regulations, that's the PSRs. Once regulation is in place, a BNPL firm who is offering a product that is also a payment service should also comply with the PSRs. The government has said it's committed to introducing BNPL regulation as soon as possible, and it intends to lay the draft regulation before Parliament shortly after issuing this response. Once the legislation is approved, the FCA will have 12 months to draft, consult on and finalise its rules for BNPL lending. We expect those BNPL products will then enter regulation around mid-2026. So thank you for tuning in to Conversations in Credit. If you have any questions or queries about today's topic, whether that's on this BNPL flash briefing podcast or the CCA reform flash briefing podcast also released today, or any other consumer credit issues, then please do not hesitate to get in touch. We look forward to hearing from you and continuing the conversation.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.